Hello and welcome back to Inside the Contract. We are still on season 1. This is episode number 6. Today's topic is taken over versus substantial completion. Legal, technical, and strategic realities under FIDIC 2017. In this episode, we clarify a concept that causes repeated disputes on major projects. The difference between substantial completion and taken over under FIDIC 2017. These terms are often used interchangeably in practice, but under FIDIC only one of them has contractual effect. Okay, few milestones are more misunderstood than taken over. Some contractors think substantial completion is enough. Employers think early use equals taken over. Engineers often delay issuing the TOC without justification. Today, we break down exactly what taken over means under FIDIC 2017, how it differs from substantial completion, and why failing to manage this milestone costs contractors millions in delay damages and defect liabilities. Under FIDIC 2017, the TOC, taken over certificate, triggers the following: end of delay damages, transfer of care and risk, start of defects notification period, DMP, beginning of employer occupancy rights, shift in insurance obligations, and reduction of contractor liability exposure. Taken over certificate, TOC, is the contractual trigger for most milestone consequences. However, if the employer uses a part of the works in a way that falls within the contract's part or early use mechanism, that part may be treated as taken over or deemed taken over, with corresponding consequences for that part. Although this is indicated in FIDIC books, I still emphasize that without TOC, the risk remains that none of these protections I mentioned above begin, even if the employer is using the facility. Contractors who do not aggressively manage the TOC process risk that they remain liable far beyond completion. All right? So what is taken over? What I'm referring to clause 10.1 in FIDIC. Under 10.1, the engineer must issue TOC when the works are complete. 2. Tests on completion, if applicable, are passed. The contractor requests TOC in writing. 4. Other contractual requirements are met. For example, as-built documentations, operation and maintenance manuals, training, etc. FIDIC includes a mandatory 28-day response period for the engineer. The wording is a bit different between 2017 and the 1999 version. Nonetheless, the subject is there. If the engineer fails to issue the TOC or reject the application within the contractual period, and if the relevant conditions are satisfied, the works or section may be deemed completed and the TOC deemed issued under the contract's deeming provisions. So you must formally request taken over. It never happens automatically. Of course, this means the contractor has met the conditions to justify the issuance of the TOC. Of course, the TOC is not issued automatically, and even when you request it, you must make sure you satisfied all prerequisites. The engineer has 28 days to either issue the TOC or reject with clear reasons or request further tests and/or documentation. If the engineer does not issue or reject within the contractual time frame, the contractor may rely on the contract's demon mechanism, of course, subject to conditions, and/or refer the matter as a dispute. I'm going to mention some reality from the mega projects in the region, what I have seen and what I have experienced with others. Engineers often ignore TOC requests because they fear employer backlash, snags have not been defined, as-built not yet finalized, or the facility management team not ready to take over, for example. Under FIDIC 2017, these do not justify non-response outside the contractual mechanism. The engineer must either issue or reject with reasons or identify outstanding prerequisites. There has to be a response from the engineer, either issue the TOC or give real, verifiable, quantifiable feedback. The term substantial completion is not the FIDIC contractual milestone. Taken over is. Common misconceptions. If the building is usable, we achieved substantial completion. Or if the client moved in, we achieved substantial completion. Or if testing is done except minor items, we achieved substantial completion. FIDIC's position. Only the TOC matters, not substantial completion. I'm going here to refer to some illustrative scenarios based on common patterns I've seen in some projects. The employer uses part of a facility for an event, but no TOC is issued. The contractor argues substantial completion. Under FIDIC administration, decision makers will focus on the contract mechanism for taking over, including any deemed taken over provisions, not informal labels. Substantial completion may be commercially relevant, but contractually meaningless without the TOC. Okay? So the contractor remained liable, in that case I mentioned, for defects, for delay damages, and for security retention. Okay? FIDIC allows taking over of sections, floors, buildings, zones, packages. Benefits for contractor. For sections, taken over typically stops delay damages for that section and starts the defects notification period for that section. For parts taken over or deemed taken over due to employer use, the contract provides specific consequences for that part, and the engineer should issue a TOC identifying outstanding items. Okay? So let's look at the early use by employer. The myth is if the employer starts using the facility, taking over is automatic. No, FIDIC's reality. Employer use does not automatically mean the whole works are taken over. However, employer use may trigger taken over or deemed taken over of a part under subclause 10.2 with corresponding consequences for that part and obligation for the engineer to issue a TOC for it, for that part, I mean. Okay, the silent killer of TOC. Tests on completion are the #1 cause of TOC rejection. Examples: MEP systems not tested, firefighting commissioning incomplete, SCADA BMS integration pending, elevators tests incomplete. interface handovers incomplete, authority approvals missing, performance tests not documented. In both editions, 2017 and 1999, required tests on completion must be properly carried out and evidenced. Where test records are incomplete or required tests remain outstanding, engineers commonly reject or defer taking over. As an illustrative scenario on a certain regional project, the contractors completed the works but failed to submit complete test reports. TOC rejected for about 6 to 8 weeks. The result, large liquidated damages exposure. The best practice, begin compiling TOC documentations 3 to 4 months before completion. Okay? So, what are the documentation required for TOC or the critical list? TOC often requires as-built drawings, operation and maintenance manuals, testing and commissioning reports, training certificates, snag list closure plan, NOC/approval letters, warranties, QA/QC handover files, asset registers, pre-handover checklists. Missing documentation equals no TOC. This is the single largest gap between the engineer and contractor expectations. Okay? I'm gonna here mention some major project case studies, especially here in the region, in the GCC region. A major project here in KSA. Contractor finished physical works, but no facility management training documentation. Missing operation and maintenance files. Interface drawings incomplete. Result, TOC delayed by 65 days. And also the resulting consequences of that delay. Another project is a project in Doha, Qatar, regarding systems integration. Contractor completed civil works, but systems integration tests failed twice. TOC delayed by 40 days. Liquidated damages applied. Another airport project somewhere here in the Gulf region. Employer used departure hall for trial operations. Contractor argued early use means TOC. Arbitration disagreed. Early use does not equal TOC. Contractor liable for defects for 3 extra years. Okay? So, what are the best practices for contractors? Request TOC the moment eligible for. Maintain a TOC documentation register. Perform internal tests on completion early. Push for sectional TOCs. Track the engineer's 28-day response period. Never assume substantial completion gives entitlement. Avoid early use without written agreement on consequences. Align MEP testing, commissioning, and facility management workflows. Build TOC into project closeout planning from day one. This is extremely important, guys. Okay, that's where many of the contractors who do not actually build enough time for handing over properly in their schedules. Okay? So just to close, taking over isn't a milestone, it's a legal transformation. If you manage it proactively, you end delay damages, limit liability, and start the DMP fast. If you wait for the engineer or assume substantial completion is enough, you risk months, even years of unnecessary exposure. Okay? So by this, we conclude episode 6. In episode 7, we continue the deep dive with the most dangerous mistakes contractors make in claims. Until then, I would like to thank you for watching, and I will see you next time.